SJC-11675, Commonwealth versus Kyle Bryant.
Mr. Black, good morning.
Good morning, Your Honor. If it may please the court,
You may proceed.
Mr. Chief Justice. So the Commonwealth's theory of this case was that Mr. Bryant was a drug dealer. He was paid $100 out of a $1,000 fee in real money, and then the rest was counterfeit money. Fairly narrow motive. Yet most of this case was littered with all sorts of evidence of prior bad act conduct.
Right. Well, before you move on from that, I just want to clarify, in the closing argument, the defense closing argument, the defense attorney relied on testimony about the counterfeit money that had been struck from the record, correct?
Correct.
So does that make all that testimony fair game basically for the trial or for the prosecutor or the jurors? I mean, did that undo what the judge did?
I don't see, I mean, I understand your point, but the Commonwealth's theory in this case was this wide. I mean, this wide. It was a counterfeit deal. The defendant, who was a drug dealer, was angry, communicated with this guy named Slick, who testified, and shot these two guys. That's their theory. Yet we heard pages and pages and pages of bringing women over to an apartment to have sex, so she would get drugs from Mr. Bryant. We heard that there were guns in the house. We heard Mr. Rounds testify that he was in jail and he went all the way over to the jail and bailed him out and became a regular customer. We heard from Mr. Hampton that talked about months and months, if not years, of dealing drugs with Mr. Hampton and with other people. I query why that is relevant to the motive. I understand Marrero. I understand the case. I understand the context of Marrero, because in that case he blamed other individuals.
Well, it may be that it was overbroad at some point, but with Slick and the counterfeit money, you don't understand that transaction and why it upsets the defendant unless the defendant's involved with drug dealing with Slick. When you look at the defendant going over to Pamela Brown's house, why is she so comfortable with him? Why does he have such access to the house? When Elaine Maloney testifies and the defendant's not as responsive as he usually is. When Scott Rounds calls and the defendant's acting differently. And I won't go through each witness, but the confession to Hamilton. What's Hamilton's relationship to the defendant? Which is tied into Hamilton working for the defendant selling drugs. It's inextricably intertwined with the whole, it's the glue of the case as it relates to the witnesses and to the motive. And I recognize that there are places where it's overbroad and where there's not, according to you, a balancing going on, but it's part of the entire motive, an explanation.
You know, this case, and I understand you're the one that wrote the dissenting opinion in Veovis, and I was involved in the trial of the co-defendant Adam Hall, the main perpetrator in that case, and I understand, you know, I have your quote in my brief about context and how context now can be used to show prior bad act evidence leading to a conviction. This is that case, in my opinion, and I think Veovis is the same case, where you've got room full of all sorts of horrible things that were basically introduced to convict this individual. And I understand you wrote the dissent on that case, and I think this is similar to this case. And I don't think that they needed to show that he brought women over to Pamela Brown's house to prove that he was mad at these two guys for stiffing him. I think the stiffing him came in. I think the phone calls with Slick came in. I think the fact that Slick was sitting there on the phone came in. That goes directly to motive. But years of his prior drug transactions, that is prior bad act evidence to show that he is a bad guy. And it clearly shows that he was a bad guy. And I think that's impermissible.
So when you say there was sufficient evidence already of motive, is that what you're?
Yes.
Okay, so exactly what was that?
I think there was testimony. I'm trying to think of who now, and I apologize. I think there was testimony that he was angry, that he got stiffed. And I think actually there are words from his own mouth, according to, I think it was Mr. Hampton, that said he actually told him that he was mad at these two guys, and if he ever sees these two guys again, he's going to. That's admissible evidence. I get it. That's an admission. It's admissible. It goes directly to the motive of the defendant.
But is it your position that the Commonwealth could have reasonably presented their case without making it apparent that he indeed was dealing drugs?
For years and for months and for bringing women over to the house, yes. Clearly, it didn't require all of that. It's the motive. I wrote in my brief the motive section in about 4 lines.
But it's not only motive. I mean, you have at least one individual who was purchasing drugs from him that night. I forget her name. And she was trying to reach him, and basically she essentially says usually he's quite responsive, but he was not responsive at or about this time, and he appeared to be in a hurry, and that time turns out to be the very time of the shooting. So that's not motive. That basically says for some reason although he was responsive to clients on most generally with regard to her, he was not responsive for about an hour at or about the time of the killing.
That's Mr. Rounds.
Okay.
And Mr. Rounds, I would suppose that Mr. Rounds could testify to that, to show that normally he's responsive and he wasn't here.
But
Mr.
I think
Rounds,
it's also Ms. Mullaney.
I'm sorry.
I think that the chief is referring to when he says to Ms. Mullaney something along the lines of, you don't know what expletive is going down right now. So I think that the chief's point is correct.
And I think that would come in. I mean, and I'm not arguing that. What I'm arguing is that the broadness of the motive, the broadness of the prior bad act testimony was way overreaching in terms of what the motive was. Anything related to the shooting of these two guys in terms of being stiffed out of the money, in terms of the statements he made after, obviously shows consciousness of guilt. I don't think I can argue that with a straight face. But I think months and months and years of the fact that, yes, he came down to the, why is it relevant to this motive that he came down to the jail to bail this guy out? Why is it relevant to the motive that he brought women over for basically prostitution to get drugs? Why is it relevant to show that, he had 2 guns laying around in the house? This is showing that he's a bad guy. And it came loud and clear, in my opinion. And then you add, and I'm going to jump to another issue only because I think it's really inextricably related. Then you add the trooper, Climbs, who blurts out that the defendant is the shooter.
See, can you show me that in the transcript? I read page 81 through 95 in the transcript, 4 times, trying to find where he blurts that out. And I couldn't find that.
Let me make sure that, I have the reference here, but let me make sure it's the right. But, I don't know that, I don't think I made it up. I think I got it right from that. I hope not.
I hope not.
If I did, I'm sure you'll take proper action, but no, I don't think I would.
No, I could have just missed it, but I looked hard. I looked awfully hard.
What happened was they brought in this Mr. Enriquez.
Sorry, Mr. Blythe, did you have the site for that?
Volume 11, page 81 through 95, I think.
And you didn't find it there?
Which date,
I can get that easily. Let me just.
I'm going to try to find it myself because I do have it in front of me. So I have transcript 1194.
October 2nd. October 2nd.
Excuse me?
Page 94, you say?
Yeah, it starts with 82, and I think it goes to 94,
Exactly.
to 95.
Oh, so it's in the very top of 94.
And I don't have the transcript in front of me, but I have,
Total of 6, including the shooters, sir.
right, that's
He
it.
doesn't say who the shooter is, right?
Well, they list the 6 people, and the sixth person is Kyle Bryant, the defendant. And he quotes Mr. Enriquez as saying he was the shooter. The thing is, Mr. Enriquez testified previously, and he doesn't identify the defendant. He can't identify the defendant because the defendant was closed and was hooded. The trooper brings in the fact that Mr. Enriquez now all of a sudden says he's the shooter and then lists all the individuals who were there and lists Mr. Bryant's name. All the other individuals testified. Clearly, the one person left out was Mr. Bryant.
He named 6 people.
Yes.
And he says included in the 6 people is the shooter.
Mr. Enriquez, the trooper says Mr. Enriquez says that to him. And then he lists, but Mr. Enriquez already testified. So, and he couldn't identify the defendant in his testimony. So now Trooper Klimas is all of a sudden saying that Mr. Bryant is the shooter, according to Enriquez, who doesn't say that.
Judge strikes it. The judge strikes it,
The
right?
judge absolutely struck it right away, but there was a motion for mistrial as well.
Right.
And this is the kind of prejudicial testimony that I don't think the jury can ignore, especially when you're now adding, months and months or years and years of all this prior bad act testimony. That's why I think it's all important and all relevant and all fits together. So, if you have no other questions, there was an identification request for an instruction that was subsequently adopted by this court in Gomes. It was denied.
During that interim period, right?
It was an interim period. It hadn't been adopted yet. But with Gomes, Mr. Gomes did not get a new trial because there was no substantial evidence presented. This lawyer presented all sorts of papers and scientific studies to back up, because the identification stuff had already blossomed.
Right, and Judge McGuire basically said, well, we got the study committee, has been adopted,
Correct.
I'm sticking with.
And really, I got to admit, nobody identified the defendant as a shooter. So in some way, this may not be an identification case. However, they did all say that's Mr. Bryant, and they did write 100%, which I know this court also cautions against on the photos, that is Mr. Bryant. Not that he was the shooter. Nobody identified him as the shooter, except now all of a sudden the trooper.
Well, can we go over that? Because I could be missing this, and if I am, I apologize.
It is a little confusing.
Okay, wait a minute. I'm going to go right over it.
Okay.
And I'm on 93, page 93, line 21. Here's the question. And in the course of identifying people that were outside the lid at the time of the shooting, were you able to identify any? Now, that should have been objected to because that's implicit hearsay, because he's only got information from other people.
From Mr. Enriquez, correct?
So it should have been objected to. It isn't. Yes. How many? A total of 6. How many? A total of 6, including the shooter. No objection, no motion to strike. No objection, no motion to strike. Who did you identify as being outside at the time? Answer, Donald Harrison.
There were 6 names listed.
Right.
Well, there's an objection, he's overruled, and then there are 6 names.
Right.
Then there's a name.
There's 6
Then
names.
there's the mistrial
And then there's a mistrial.
motion.
So there's
So the court is right that there wasn't an objection at the very first interaction, but there was later.
And Mr. Weinstein at sidebar says he just identified my guy as a shooter.
Right. That was a
He
sidebar.
fills in the gaps at sidebar.
That was a sidebar conference. He said he just identified my guy as a shooter, and nobody did, including the guy who was looking at the videotape, Enriquez.
So how do you get prejudice arising from the failure to use the eyewitness committee's instructions if there were no true eyewitness IDs, except for individuals who said, I know Bryant, and they basically showed him a photograph and said, is that the guy you know to be Bryant? He said, yeah.
The only, and I admit that is,
Not your best argument?
Not my best argument, thank you, Justice Graziano. Thank you. However, when you have these two individuals, Mr. Hampton and Ms. Brown, saying 100% that's the guy who brought girls over brought girls over for sex and for prostitution and for drugs that lasted years and years and years, it's an identification in a way that is prejudicial when it ties to issues 1 and 3. That's my best argument.
We distinguish between circumstances in which somebody is saying, basically, I identify that person as the shooter, versus I happen to know this person incredibly well, and the police, in order to verify that the person who they think they're talking about is the person they know to be the defendant, shows them a photograph of, I guess at that time, the suspect, and says, when you speak about Bryant, whatever nickname you use, is this the guy you mean? And the answer is yes. And that's not within the realm of what we consider to be an eyewitness identification. That's a verification that we're talking about the same guy.
Understood. Understood.
And I think all you had here was a verification that the guy who I'm referring to as Bryant, or perhaps by a first name or nickname, is the person who the police understood to be Bryant.
Correct, and they put 100% on the photos and all that. Nobody identified him as the shooter. I'm not saying this over and over again just because Justice Lowy is here, but Justice Lowy is here, and also I'm saying this because I know that case really, really, really well, since I tried the individual who was actually the gang leader in that case, a 3-month trial. Veovis was the last trial, and ironically the first one that went to appeal before you. But the quote that says, the court purports to announce a new brand of identity evidence which involves the use of similar but not distinguishable conduct of a defendant to infer that the defendant acted in conformity. If this sounds like language often used to describe the type of character interference that fact finders are profoundly prohibited from making, that is because it is, and I think that is really appropriate in this case. And with that, if you have no other questions, I'll sit down.
Okay,
Thank you.
Ms. Anderson, good morning.
Good morning, Your Honors. Audrey Anderson for the Commonwealth. If it pleases the court. If I may, I'd like to start with the testimony of Tremaine Hampton, Scott Roms, and Elaine Mahoney regarding the defendant's narcotics distribution, because it was relevant in explaining the defendant's motive and his state of mind in killing the victim.
And what do you say in general principles to your brother's argument that there was just too much of this prior bad act evidence that made it, maybe you could get in some, but not quite so much going back so many years before you get down to specifics? Let's just talk about it in general terms.
I'm wondering where all these years are coming in. He's saying that there's a lot of years. They're not talking about specifically the drug dealing for so many years. Specifically, they was talking about him knowing Pam Brown, Scott Rounds, and Elaine Mahoney, that they were his customers for years. Some of them had already stopped. I think Ms. Brown had already stopped using drugs, but it was to show their relationship with the defendant.
And that would show exactly what?
That showed the defendant's state of mind. Their testimony was given concerning after the shooting. And I could go one by one, but the testimony,
That's all right.
tons of testimony. But they knew the defendant well. They always described the defendant as being a very cool, unemotional, very polite man. And at this time, they said he was just not himself. He wasn't answering his phones. He was late. He was nervous. He made admissions that shit went down. You don't know what's going on. I got to get out of here.
Can I ask you about Mr. Rounds, though? So Mr. Rounds' testimony, the jury finds out that he was in jail, that the defendant provided the bail money for him to get out of jail, and that Mr. Rounds used to, back before he went to jail, used to buy drugs a lot from the defendant. Did the jury need to hear about that?
I think the jury needed to hear about that. I don't think it caused any prejudice because he was giving the defendant his last payment that he owed the defendant. And this was right, say, before or after the murder, and he was calling him to say, I have your last money, this is it. And the defendant finally called him back and said, hey, I gotta go, I'm in a hurry, and hung up the phone. You could have just used Elaine's testimony, where she waited over an hour, hour and a half for the defendant that night. But you want to give the jury a clear picture of what's going on. You want to give them a complete picture of what's going on. And it was those two witnesses, well, Pam Brown also gave, but he didn't refer to Pam Brown. Pam Brown also gave a testimony concerning the victim that night.
Okay, so giving, in context of giving the jury a complete picture of what's going on, it's clear the Commonwealth's theory was that this counterfeit money was the cause of what provoked the defendant and caused him to shoot the victim.
Yes.
All right, aside from any just drawing inferences about this, what actual evidence was admitted that showed this? So I know we can draw inferences, but do you have any direct evidence or any testimony, anything in the record you can point to that shows conclusively the defendant knew that Cox or the victim were the people who used the counterfeit money?
Well, he told Tremaine Hampton.
And that came in, correct?
That came in. He told Tremaine Hampton that Mr. Flory had done a drug deal for him, and he was supposed to receive $1,200.
Yeah.
He received $100 in counterfeit, and he received $1,100 in counterfeit. And he told Mr. Hampton that he was going to wait his time. His time was coming, and that he was going to get him.
So it's a specific testimony that Hampton knew, that the defendant told Hampton, I got counterfeit money from that guy.
Yes, definitely. The bartender at the Lit, Mr. Fleury, also gave him a $100 bill to test. I'm not sure if he said that.
Wasn't Hampton's testimony struck because it was hearsay?
No.
No? Okay.
Okay. The bartender tested the money, and it was counterfeit. Okay. And I'm not sure if he told, if Mr. Floyd told the bartender at the time who had given him the money. Okay. But I guess I'm a little lost here now.
I'm sorry, I didn't mean to do that.
That's okay. Are there any other questions on this testimony itself?
No.
So this testimony is fine. Okay.
We haven't declared that yet. but-
Okay, I was hoping. Okay.
We've declared unfinished asking you questions about that testimony.
But do you have any questions about Mr. Hampton's testimony, Mr. Round's testimony, Ms. Mahoney's testimony concerning that? It's all set? Okay. The identification testimony?
Yeah, what do you think about the testimony of the trooper and blurting out the name of the defendant as the shooter? Is that how you interpret the testimony?
No. It was concentrated more from what I read. It was saying that he watched a video And because of the video, he is identifying the defendant. But starting on page 93, it says that, he clearly says that he got information through witnesses. And why did you try to identify people that were out behind the lit? Just the witnesses interview, sir. And in the course of identifying people that were outside the lit at the time of the shooting, were you able to identify any? Yes. How many, sir? A total of 6, including the shooter. Who did you identify? Judge Lara, I guess you went over this. Donnell Harrison. Then he went Donnell Harrison, Sean Cox, Wayne Ochapiti, Micah Martins, Robert Enriquez, and Mr. Bryant. Then there was the objection. But it seems to be they're objecting because of the video recording, when he said that he got all of his information from the witnesses. But
Wait, you're not going to tell us, maybe you are, that it was appropriate for the trooper to characterize the person he saw in the video as the shooter, and then identify essentially the shooter as the defendant?
I don't think that he was talking about the video. I think he was talking about the information that he got from the other witnesses. I don't see how he could have identified the
You're able to
defendant.
identify any? Yes, sir. How many? A total of 6, including the shooter. Is it appropriate for the investigating officer to be giving that testimony?
If it's the way that you say it is, no, it is not.
That's how it's read in the transcript.
Okay.
Reading the transcript.
Well, do you think maybe they meant not, yes, that's you, but could you figure out who the shooters were? Yes, I could, or was it an investigation type of question versus an identification question? But they used the word identification?
I think it was identification from witness testimony.
I see.
That they, not witness testimony, witness interviews, but either way, he shouldn't have said it.
All right.
And the judge promptly struck it from the record, and he gave curative instructions. He told the jury before testimony even begun that anything that was not to be admitted that was improper, he was going to strike it. And he did strike it. And he told the jury that the only people that would make an identification from the video would be the jury, and that they were to disregard the identification that the officer had made.
Did the judge refer to his, I know he did in the beginning of the trial, but in his final charge, did he also tell the jury, if I struck something, it was out in the final charge?
I'm not sure. If he did, it would be in my brief.
Okay.
Okay. Are there any other questions on that issue? Are there questions on any other issues, Your Honor? All set?
Okay, thank you.
Thank you very much.